of the child. And so the next issue to determine is whether each or both of the accused persons are the ones who caused the death of the deceased. And then finally, we'll be answering a question: if they did they have malice aforethought? Because you can cause a death, but you didn't have malice aforethought, and of course, that may be manslaughter. We are dealing with death. So they need not just to prove that they committed the offense, but there was malice aforethought. I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person for ease of understanding and flow of the judgment. And so right now, I'm analyzing the evidence the prosecution have adduced in answer to the question as to whether the first accused person caused the death or killed, bluntly put, the deceased. Under this particular issue, I have discussed several items just for understanding of the parties. And let me just mention some of the items that fall under this. There is the issue of identification parade. There is the issue of the clothes which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner, again, for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nanda treated me to good substance, not good in the sense that none of the other people's substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages of 35 pages, is really a summary of what the parties submitted, okay? But I would like to read it out in brief for us to know. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following: that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth, changed into those clothes, went to the deceased house, committed the murder, changed out of those clothes, and that's it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her to submit before the murder or in the course of the murder. It is the submission of the prosecution case that after the accused person, that is the first accused person, had committed the offense, he went and destroyed the cloth, which would have been used as evidence in this case. It is the prosecution case. He then shot himself to divert the attention of the investigators from investigating the murder charge to investigating a shooting incident. The family of the deceased concurs and associates themselves with the prosecution case and invites this court to note that the evidence by the first accused person that he did not know the deceased is insincere. And they draw the court's attention to the fact that there is call data that speaks to the contrary. And the family of the victim submitted to this court that it should take cognizance of the fact that motive is irrelevant for purposes of proof of the offense of murder. What did the first accused submit on? The first accused persons have submitted that the description given by the prosecution witnesses on the clothes that their first accused was wearing is generic in the sense that those clothes did not have any marks that would identify them specifically out of any other clothes of the same kind. The first accused person has submitted that there was a lot of contradictions in the prosecution witnesses' testimonies. I have analyzed what they are inviting this court to consider as contradictions, and they are as follows. One, that there are contradictions on the time when Haron entered the deceased house and left. And that saying those contradictions arise from the record held by the protected witness number 3, the guard at the gate, that shows that Haron entered the deceased house at 23:21 and left at 23:31. And therefore, that suspected killer was in the deceased house for only 10 minutes. And they are submitting, is it possible to commit a murder in 10 minutes of this kind? They have submitted that the person whom the court is being invited to deem as the first accused person and who has been identified as Haron is not the first accused person. That the prosecution have failed to show the nexus between Haron and the first accused person. They have invited this court to look at the contradictions as they relate to the evidence of the witness number 8, Jennings, that the first accused person had a bag in which he carried a white counsel when all other witnesses